appeal, but a matter of real bank of Canada and commissioners on His Majesty's Revenue Department.
Good morning, Mr. Bremner. It's much cooler in here today. I hope that's better for everybody. But in fact, now I've got a blast of cold air. Never satisfied. And it can't be shifted. Never mind. Please do continue.
I'm obliged, the lady. Just by way of housekeeping, the court should have hard copies, I hope, of the transcript at each of your places on the bench, as well as the transcript in soft copy having been provided overnight.
Thank you.
I'm going to make my points on a number of the materials that you were shown yesterday, but just to frame what I'm going to say about those materials. We're dealing with Milano Friend's ground one of his appeal, and we're looking, of course, at the fifth limb of Article 6.2. We've been looking at that. I'm sure the court has the wording well in mind, but in the version that's at page 46 in the authorities, is where Milano Friend showed it to you. Now, the proposition that Milano Friend needs to get home on his ground one is that the fifth limb is limited to grants only of the right to work. When we're looking at the fifth limb, the starting point in my submission must be the text. We need to look at the conditions. What we're asking first is, are there rights to payments? There's no dispute about that in this case. Payments of what nature? Well, they have to be as consideration for something. I'll come on to the what in a second. As consideration for that can't, in my submission, be a reference to some technical English law notion of contractual consideration. This is a tax treaty using language that's borrowed from the OECD. And Article 6.2 has to work, among other systems, for a civil law system that does not or might not recognize the English law notion of consideration. Same point would apply for a mixed system, which doesn't have that doctrine. Scotland, an obvious example. So as consideration for just means in return for, and that's in line, as it happens, with the use of the word pour in the French text.
Sorry, just in...
And as it happens, that's...
No, just in return for.
Yes.
Yes.
I'm so sorry. Yes. Now, in return for what? In return for the working of, or the right to work, put short, natural resources, and there's no dispute here, we're dealing with oil, and that's within that description. Now, there's no requirement, if one looks at those conditions, as to the particular manner in which the right to work is acquired. There's no reference to any particular national law mechanism or anything like that, nor would one expect there to be. So no doubt the right to work, a right to work which is within the fifth limb, could be a right acquired as a result of grant, but it doesn't have to be. That's the burden of my response to Milano Friend's ground one. Now, just to pick up two of the points that Milano Friend made orally in relation to the various features that he identified, just to make sure I've dealt with those before I turn to the materials. Milano Friend's first feature was to emphasize that one needs to identify income from immovable property. And he's absolutely right. That's a condition in Article 6, sub 1. That point doesn't help the analysis here, because what we are asking in relation to ground 1 is, does the fifth limb apply? If the fifth limb applies, we have immovable property. And necessarily, the payments, when they are made, on the footing that the rights in question here are immovable property, those payments are from the immovable property. They are from the rights themselves. So pointing to the word from in Article 6.1 doesn't help in my submission in analysing whether we're inside or outside the fifth limb. A similar point arises in relation to the second feature that my learned friend relied upon yesterday. That was to say that Article 6.3 he submitted is restricted to dealers only. And the court will recall Article 6.3, that's the provision saying that the provisions of paragraph 1 apply also to profits from the alienation of such property. Now, I don't accept that it's dealers only. You could have income arising in a variety of ways, but let's put that to one side for the moment. Article 6.3 is about, if one looks at page 46 in the authorities, it's about profits from the alienation of such property being, of course, immovable property. So if you relate that to the fifth limb, the item that would be being alienated, if we're looking at Article 6.3, would be the right to the payments. And again, that doesn't inform, in my submission, the prior question of are we in the fifth limb or not in the fifth limb in the first place. What we're talking about here is the question as to whether there is some restriction within the fifth limb that ties in to the manner, in terms of particularly domestic law mechanism, in which the right to work is acquired. And that is a different point, both from 6 sub 1 and 6 sub 3. So neither of those first two features help.
Mr. Bremner,
yes, ma'am.
Obviously we don't construe the fifth limb in isolation.
Of course.
We look at it in the context of Article 6 and indeed the treaty as a whole. Can I ask a slightly different question that is troubling me? It is about 6.1, but not the income from. The way 6.1 works is that if you do have income from immovable property, there's a power to tax it in the contracting state in which such property is situated.
Yes, ma'am.
I'm struggling a bit with how you apply that to property in the form of this sort of right. Everyone sort of assumes you look, I think everyone's effectively assuming that you look through to the underlying property. You've all been talking about the continental shelf and that being part of the UK. But as you've pointed out, the immovable property on which you rely here is not actually the underlying interest in the North Sea. It's the right.
It's the rights to the payment, my lady,
Yeah.
Exactly so.
So how does that work? And might that shed any light on the proper scope of the definition?
So it has been common ground throughout, and Learned Friend has accepted throughout, that if the fifth limb applies, then
that's not my question.
No,
my question is about the interpretation.
Oh yes, no, I'm dealing with that. Sorry, I'm just trying to take it stages. Stage one is your ladyship is right that it has effectively been assumed, because it's been conceded on RBC's side, that if we are within the fifth limb, no additional point has been taken to say that the rights are situated other than in the UK. That's why you won't find a discussion on
but it's not my point.
No,
my point is whether it
helps
with the interpretation, and it's actually rather possibly related to the submission being made about grant.
Yes. What it doesn't do in my submission is point you in the direction of restricting the fifth limb to grant only. Because what you have to do is you have to ask, well, what is the location of those rights? You might, for example, have to look to rules of private international law in the domestic states. That might be one way in which you might do it. In the present case, whether you're looking at a grant or whether you're looking at a transfer, you would have the same problem. You'd have rights that are being created. And your ladyship would be saying to me, well, where are those rights situated in terms of Article 6.1? And my answer to that would be whether it's a grant or whether it's a subsequent transfer, you would be taking into account the location of the natural resources to which the rights relate, because after all, what we're interested in is the close economic connection between, if I say the land in general terms, here it's the continental shelf, and the income that has been generated that relates to that land. So you'd have exactly,
Yes.
my point really in a nutshell is that you'd have exactly the same difficulty in terms of working out the contracting state in which such property is situated. But difficulty may not be quite the right word. You'd have exactly the same exercise to do whether you were to say we're looking at a grant situation or at a transfer situation.
Well, the exercise is possibly not so difficult in the case of classic mineral royalties arising where, say, a landowner creates, or a person with an interest in land creates a right to work.
I'm terribly sorry, I'm just struggling to hear you.
So it's my voice at the
Let me
moment.
show you,
I
close the window.
apologise.
Yes.
The difficulty is perhaps less where you have a classic mineral royalty situation. So, landowner, person with an interest in land, creates a right for someone else to work the land in exchange for payment, receives those payments. There's a clear link to the land interest and to the location.
I wouldn't accept that because what you are scrutinising is the right to the payments. That's something on this hypothesis that's been created. It's something other than the land itself. And whether you say it's a bit like this maps into the slightly different way in which your ladyship yesterday said to my own friend about the quality of the payment. Is there something about a quality of making payments to someone who would otherwise have the rights themselves? It's the same sort of point, I think, that your ladyship has in mind. But one has to bear in mind that what one is scrutinising is the right to the payments. That's saying the link is more obvious is simply a way of saying, well, it is easier to say factually that is the place to which that right should be related in a grant case. Now, I don't myself accept that, because whether it's an original grant and the Crown still has title in a general sense to the continental shelf, or whether you are dealing with a party like Sulpetro, who on day one had a right to work on my case. I mean, ground two is to do with whether that's right or not. But a party who on day one had a right to work and on day two transfers that to somebody else, the link in my submission is similar in nature.
Yes, but I just come back to the fact that we need to read the fifth limb in the context of Article 6. Article 6 is getting at giving the contracting state in which the property is situated a right to tax. If you have a purely contractual right, let's take an overage payment on the sale of land, potentially to a foreign buyer.
Yeah.
Is that property of English property? Is that property situated? I mean,
that might be.
I know it's outside the fifth limb, but you see my point.
Well, you would need to develop criteria. You're not given criteria expressly in 6.1 for situation. I mean, what you referred to as a result of Article 3 is the domestic law of each of the contracting states, and that's why my initial response said, well, the obvious place to look would be the rules of private international law, I suppose. They could tell you particular rights are located or what system of law they're subject to. That would be an obvious place to be searching for those criteria.
Is that true?
That doesn't quite get you to the answer you want, because as a matter of private international law, the situs of a debt is usually where the creditor is resident.
That is,
and you don't want the answer that the right to the payment is in Canada.
true.
So you have to have an answer which says, even if as a matter of private international law this is a debt which is located in Canada, for the purposes of Article 6 of this double taxation treaty, because it's income from immovable property, this assumes you're right on the fifth limb, it's therefore treated under Article 6.1 as being situated in the UK. Now, I understand why you say that, because the whole point of this is to enable the state where the underlying real property is situated, in this case the oil in the North Sea, to tax that resource. So you can get there, but I don't think you get there by saying, look at the rules of private international law.
That may be a shortcut to nowhere. I can see your lordship's point. But one would have to take into account in making that determination about location the underlying nature of what the provision is trying to do, which is trying to tie the profits, if I can just use a neutral term, that relate to, and again, the land. I know we're talking about the continental shelf, but it's trying to maintain the taxing rights in the source state in respect of profits that have a sufficiently close relationship to the land. That's a matter that one should be taking into account in working out where the relevant property is situated. Because my Lord Justice Nugee is right to say, well, it can't be right on my analysis that you would suddenly jump to say, oh, actually, it's debt. We just look and we find that the situs of the debt is overseas, and oh dear, we've suddenly switched off the UK's taxing rights. That's not a sensible interpretation of these provisions.
No, but I think my lady's point, if I've understood it, is this. It's quite easy to see if you're a landowner. Let's get away from the continental shelf. So suppose you've got a quarry on your land. It's quite easy to see if you're a landowner and you grant someone else the right to work the quarry in return for a royalty on each ton of stone extracted. It's not difficult to see that the right to that payment takes its character as immovable property from the fact that what you're doing is granting the right to work the land.
Yes.
But it's not quite so easy to see that if the quarry owner then assigns that to somebody else, that the consideration they get for assigning that to somebody else is so closely connected with the land.
Well,
I think that, as I understand it, is the point.
I'm doing my best to deal with it. I'm not sure I accept that it's more difficult to see the connection. You still have the working of the land is happening. Money is being paid in return for that. The fact that the original owner in the grant case continues to own the land, perhaps it does make it more obvious, but it doesn't follow from that the original grant case is the only case in which this provision is capable of applying. So I suppose I take it in two stages.
So you would say, if the quarry owner sells the quarry, the right to work the quarry, to somebody else, the payments they get for that are within the fifth limb?
Yes, I would.
Yes. And that's a clear distinction between you and Mr. Peacock, who said it just doesn't come within that at all.
Yeah. And the same follows if the person who has the right to work it assigns that right. And your simple, I think, analysis, and I'm not suggesting anything is simple, just sipped out, it is that everything which derives, every profit, every payment, one way or another, which derives originally from the quarry or from the mineral resource, from the oil, is covered.
Yes,
I think that's
whether-
where
whether-
you end up
whether
with
I
a
need-
very broad
Whether I need to
proposition.
go so far to say that it's every payment, I'm not sure. I mean, if I do, so be it. But what I'm dealing with here is a circumstance, and we'll get into more detail on the particular nature of the rights that the different parties had when we look at Ground 2. But we're looking here at a circumstance where there are valuable resources under the seabed in the UK. Those resources are being worked and exploited and tend to account. And the question that the court is going to need to grapple with is, well, are we within 6.2 only in that case of original grant, or is a subsequent assignment also within the scope?
Well,
and you can,
let's be clear what. I think Mr. Peacock accepts that assignees of those sorts of rights,
Yes,
payments made,
that's
would be. Well, what we're talking about, let's be clear, is consideration for the alienation of the assignment, the sale.
So yes, as I understand it, my own friend would accept that if, so I go back to my Lord Justice Nugee's mine owner example, if the mine owner had assigned his own interest in the mine to B, and B grants license to C, then my own friend would accept that that's a fifth
Or I
case.
think if the quarry owner assigns sold subject to and with the benefit of the existing arrangement to B, B would then get the.
Yeah, so some
I think we need to be a little bit. It may be better to refer to the facts of this case. What is said to be excluded is consideration or defer consideration for the disposal, outright disposal.
Yes, I mean I've tended to use the term transfer. I mean it does bring up a wider point which I was going to get to really under Ground 2, but I suppose it's potentially relevant to this as well, which is that there is one also has to bear in mind that one has to have clarity about what one's talking about when one talks about the right to work, because Lanford hasn't really expressed a position on this in his submissions, either in writing or orally, but I think the assumption that underlies RBC's case on this appeal is that the right to work is coextensive essentially with the right to drill.
The license.
Yeah, exactly. So that and only that. And one of the points between us, which I'm going to develop, and I've trailed this in Ground 2 in my skeleton, is that I say one needs to take a slightly broader view, and actually one is interested not simply in the right to go and drill, it's a right to exploit. And one has to see that notion of the right to work in that slightly broader sense. I just simply note that at this stage. So I take my Lady Justice last point. We have to look at the transaction in this case. One does have to be careful in dealing sequentially with Ground 1 and Ground 2 that one doesn't let the two sets of points bleed into one another. Because what we'll see is that what was transferred is Sulpetro, the parent. It sold essentially all of the contractual rights that it had, and it sold the shares in its subsidiary. And as Malone Friends Peacock explored with Lord Justice Nugee yesterday morning, the subsidiary really had nothing in it other than the piece of paper. There was nothing of real value in the subsidiary. So it's right, I suppose, in a general sense to say this is a case of alienation or disposal in the sense that Sulpetro was selling rights. but one does have to be careful in looking at the facts of this case, at the particular nature of the rights that it had, because they were arranged, set up in a slightly unusual way because of the illustrative agreement. I'm sorry, I think I was in the middle of trying to answer a different question. I'm not sure where I fully have, but we may well come back to it. I suspect. Yes, I think what I was trying to say, just so I have at least said this, is that if there is any problem of that nature, it certainly isn't solved by drawing a line between grant on the one hand and alienation on the other. And there was a reference yesterday to an example that my learned friend gave that rather shows the slightly odd results that would eventuate on his analysis. The court was the example, I think, of the 1,000-year lease. And it was said, well, in that sort of circumstance, what I have left is very, 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 very thin. But that is still capable of being a grant-type case, contrast to complete alienation. And that should, in my submission, lead the court to start to really wonder quite strongly, well, actually, is this the sort of distinction that the draftsman of 6.2 would actually have in mind? And one could make a similar point about, for example, a contrast between a sub-license, which, as I understand it, learned friend would accept as within 6.2, and what my Lady Justice Falk describes as an alienation case, which my learned friend says is not. And the point I've made, which has been accepted below, is that there is no reason of principle for dealing with those two situations in different ways when we look at Article 6.2.
Sorry, say that last bit again.
So, my learned friend, as I understand it,
yes, you say there isn't a reason in principle to deal with them differently.
Yes.
Sorry, I've got it. Thank you.
I was going to pass now to the materials. I'll try and do this relatively briefly, because my core submissions, they don't really assist in the task that this court has for various different reasons. The first item that was referred to was the UK-US Treaty from 2001. And that is in Volume 1 of the Authorities, Divider 11, starting at page 192. What is being relied upon is the definition of real property. As the court will recall, Article 6 in this treaty, which is at 202, is, as a matter of drafting technique, just framed slightly differently because it doesn't have Article 6.2, because that's effectively, or the equivalent is set out in the definitions in Article 3. So in Article 6, we're talking about real property. I'll leave to one side that probably arid semantic point, not immovable property, but in 3.1m, electronic page 198, one sees in particular that an interest solely as a creditor, it's the brackets in the first line, that's excluded. And there's no equivalent to that exclusion in the treaty with which we're concerned. So one does have to be careful in looking at the US materials because of that. And the Upper Tribunal in my submission was right to note that in paragraph 144 of its decision. There was also reference, although we didn't look at it, to US Treasury guidance on the US-UK treaty. My friend gave the reference. I'm just taking this in two stages. My position is that that US Treasury guidance is not a valid aid to the interpretation of our treaty for the reasons set out in Irish banks. It's a unilateral document produced by the US Treasury, the tax administration of another state. It's not a document agreed with the UK. But if we are going to look at the guidance, we'll see that it actually doesn't help RBC's case. Just to preface this by reminding ourselves that the reason that law firm was looking, certainly in his skeleton at the guidance, I think it was Article 13.2 in the US Treaty, which is page 210. And that brings within the notion of real property for the purposes of Article 13, among other things, rights to assets to be produced by exploration, etc. Now, looking at the guidance, that's in Authorities Volume 3. And it's tab 28, starting at page 614. Rather a lot seems to have put in. The only bit that I think is actually relevant, I'm not sure if this was actually the page referred to, but the bit that's relevant to Article 13 is on page 666. This is the US Treasury's own commentary on Article 13, and in relation to paragraph 2, which I've just shown the court, what it notes, does the court have, there's a heading paragraph 2 halfway down, it's the fourth paragraph on the page. They're not numbered, I'm afraid. But starting this paragraph defines. And you can see in that first sentence that what paragraph 2 is doing is defining real property to include assets that might not, and I underline might not, be considered real property under the definition of subpara 1M, which was the general definition that we looked at a few moments ago. So the guidance isn't saying that the assets which are identified in Article 13, that they are not real property. It's not saying that, it's saying they might not be. And actually, if one looks further on in that fourth paragraph on Electronic 666, one sees that in the case of the United States, such rights would be treated as real property. That's under a particular provision of US law, which I'm afraid I'm not in a position to help with. But that's the view of the US Treasury. So actually, if you look at this from the US Treasury perspective, they don't need Article 13 in order to bring in the rights that are identified in 13.2. So all that guidance does in this submission is
you meant to say, it goes on to say that such rights would not be treated as real property under UK domestic
in the view of the US Treasury.
That's right, isn't it? A barrel of oil is not real property once it's out of the ground.
Well, if one's looking just at the barrel of oil, that's, of course, oil once won is movable. And my case doesn't depend on...
Well, that's all they're saying, as I read it.
Yeah.
If the oil is still in the ground, it is presumably real property under English domestic law, isn't it?
I would have said so. I would have so submitted. Now, the other instrument that we were taken to was the US-Canada Treaty, and that was particularly Article 6, Roman 6, in that treaty, which is in Authorities Volume 1, tab 7, starting at page 131, and Article 6 is at page 136. And reliance was placed on the words just before the semicolon, the final semicolon in 6.2, rights to amounts computed by reference to the amount or value of production from such resources. Now, in my submission, I don't need language like that in order to get home in this case. And it's a mischaracterization, as I'll submit when we get to ground 2. It's a mischaracterization of the facts in this case to say that all that there is here is a right computed by reference to the amount or value of natural resources. As we'll see, what we're dealing with is payments for Sulpetro's rights under the illustrative agreement, and those rights included the right to direct the work programs, they included the right to Oil One, and the rights were also for the shares in the subsidiary, which was, as I've said, just a repository for the license. And looking at it from BP's perspective, BP needed all of those elements in order meaningfully to be able to work the oil in the Buchan Field and turn it to account. And if we're looking at the trigger for the payments themselves, they're payments that arise out of the sale of the very oil that's extracted from Buchan. So this is not a case of payments computed by reference to the amount or value of production. We're not dealing with some sort of derivative or index or something of that nature. So while it appears that my learned friend would accept that if we had wording like that in our treaty, we may well not be here, my submission is that that alternative formulation, it doesn't really help us in working out the limits of the fifth limb in Article 6.2. In particular, it doesn't justify a conclusion that Article 6.2 applies only in relation to the grantor. So those were the other international instruments.
I think you submitted yesterday that we shouldn't be looking at those
Anyway.
Indeed. Although because they are not bilateral instruments between the relevant.
Absolutely, my lady. My submission is that what this court is seeking to do is to identify on an objective basis the true nature of the agreement between the UK and Canada. And so in that sense, this is actually much more akin to the sort of contractual construction that one does in relation to a regular contract, but of course suffused with, supported by established principles of public international law. And we looked at ANSA, and I've shown the court a little bit more from Irish banks, and those principles are not controversial. I do say that what one certainly cannot do is to look at these alternative forms of wording and to say that that means that the UK must have accepted that payments of this nature are not covered. There is, of course, a different point, which is to say, well, wording of this nature was needed, and if the UK wanted to catch it, then it would have said so. I understand that point, but the burden of my case is that I get enough out of the language that has been used that I don't need the more extensive wording. And one does, in my submission, have to be very careful about saying, well, because it could have been put in a different way, that means that one must read a limitation into the fifth limb in 6.2, because I do remind the court that is the burden of my learned friend's case. That's why I started with the text, that there isn't any restriction of the nature for which RBC contends on the face of Article 6.2. That's why my learned friend has had to say, well, we have to look at things as a whole, we have to look at it in the round, and I go here, there, and to different places to find materials to justify my conclusion that I can then bring this back into Article 6.2. And one does have to be very careful of that exercise.
Can't you legitimately say all these double taxation treaties that we've been shown are all based on the same model, which is the OECD model, And it is a legitimate point that the US and Canada, when they wanted to take that as their starting point, but capture a particular type of payment, thought it was necessary expressly to say so. Is that not a legitimate? Because what we're trying to construe our text. I understand that. We can construe our text against the background of the OECD model, because that's undoubtedly the source of it.
Yep.
Is it not a legitimate consideration to say when other people have looked at that source, they thought this text needed extending to capture a payment of this type?
Well, the most one can say is that they thought it might need extending.
It might need extending.
Which is why I say that if you are going to look at this, it gets very little weight indeed.
Yes,
It's a sort of a contrario type of reasoning. It's the sort of thing one
I mean, one can always say when construing a contract, but if they'd meant that, they could have said so expressly, which is never an argument of great weight, because if they'd said it expressly, there wouldn't be an argument.
Well, that was the point I was attempting to make. I think when we close, yes.
Yes, but I think it does go a little bit further here, because these treaties are based on the same underlying model text. So not only can you say that you could have said something expressly if you'd wanted to say it, but other people have said something expressly when they wanted to say it. And that seems to me to add a little bit of weight.
That factually is right, that other people have said other things. It doesn't, in my submission, disturb my core point that you can't take that and then use it to read down the
I understand that point entirely.
In the model.
Yeah.
There is possibly when I looked at the commentary that there is on Article 6, which, as you say, is quite limited, also has various specific country reservations. Are you going to go to that?
I wasn't going to specifically, but there is
I just think it is an echo of the same sort of point there.
There is a list, certainly,
Yes.
of particular items that you can see for the one I'm afraid that popped into my head immediately is not terribly helpful for this case. I think it's in business profits, and Greece in the context of shipping was simply the one
but I mean on Article 6.
On Article 6, there are
Canada, among others, have
Indeed.
reserved.
Indeed, that's right. Now, that obviously raises the question of did they actually need the reservation?
Indeed, but I'm simply making the point that, just as my Lord Justice Nugee made a point about other treaties, the fact that countries have expressed reservations, or not necessarily using the right term, in the commentary, which I think it's agreed it is commentary we can have recourse to. What is said in those country reservations might also conceivably be relevant.
I'm just looking at.
I'm not sure where it is.
Well, I was looking at 2017, which is at 883, which is not the one we've been looking at.
I'm sorry, I couldn't hear you, Mr. Brenner. Where are you?
I'm so sorry. I realised I was looking at 2017. So if you just give me one moment, I'll find the 2005 one, which we were looking at. Yes, the 2005 one's at 787. I think I'm right in saying, because I checked this, I can't get this from the text that's in the courtroom, but I checked this when I was preparing, that the first two reservations, so Finland and Latvia and France, that they were there in 1977. Other ones have come in later, nothing probably turns out that. But the reservation that my Lady Justice Falk has in mind, I think, is 8, and Canada 787.
Yes, but also actually to an extent, New Zealand and Australia, so 9 and 11, rights relating to all, very broad wording, rights relating to all natural resources.
Yes, indeed. But the point about those reservations is that what they don't get you to is to a place where, for example, a transfer of the right to work is not caught in circumstances where a grant is. And you can see a much broader policy line. Take the New Zealand case in Article 9. We want to have taxing rights in relation to rights relating to all natural resources. That is far broader than anything that we're dealing with just now. So there's an obvious function for the reservation.
I'm not suggesting for a moment that the reservations provide the answer to this case. I'm just raising it because it's a sort of allied point to whether it's relevant at all to look, for example, at the US-UK or UK Canada-US treaty.
I was going to go next to Article 12 and points that were developed under reference to Article 12 and the related commentary. Now, Article 12, the text of it is authorities.
50.
It is. I'm very grateful. I was looking at the OECD and I got myself confused. There are too many versions of similarly numbered things in this one. But, electronic page 50. I'm very grateful to know that. And the definition of royalties we looked at is in 12.4, halfway down the page. I'll recall that from yesterday. And what my friend has sought to do is to draw a comparison between that article and Article 6.2. Now, I make a number of points on this. First and obviously, the payments that we're dealing with in this case, they can't on any view be royalties within the meaning of Article 12 because they don't concern intellectual property rights. So we are dealing with a different provision, dealing with a different kind of income, and it certainly is not obvious that there should be any read across from Article 12 to Article 6. Second point is that the structure and the language of Article 12 are different in a number of respects from that of Article 6. First of all, in 12, we're talking about a payment for the use of or for the right to use the copyright. We're not talking about a payment for the working of or the right to work, in this case, the oil. Now, my learned friend says that, well, those terms are relevantly similar, I think was how he put it. I don't accept that. We're not looking at the same phrase. Working and using are two different things, and one can't assume that each of those concepts should be interpreted in the same way. There might be a sort of echo of the rhythm of the phrases, but it's no more than that. So using copyright is one thing, working an oil field is a different thing. I simply make that point on the language. One also has to bear in mind that in relation to Article 12, it is the payments themselves, if one looks at 12.4, that are the royalties. And I made this point already for Article 6, it's the rights to the payments that are the immovable property. So one doesn't get anything directly out of the article itself, and I don't think it was really suggested that we did. The thrust of the case really was by reference to the commentary on Article 12, which is where I'm going to go next, but I think there may be a question before I do.
Just your last point, under Article 6, the immovable property is the right to the payment. But what's taxed is not the right to the payment, it's the income from the right to the payment, which is the payment.
Yes.
What is the difference between that and payment of a royalty for use of copyright?
What in terms of what is?
Well, you made the point. You made the point that the definition of royalty is a payment, whereas in Article 6, the definition of immovable property is a right to payment. Article 12 directly taxes the royalties that are paid.
Yeah, gives taxing rights in respect.
Gives taxing
in respect of royalties arising.
Royalties paid. And I haven't quite understood what the relevant distinction is between giving a taxing right for income received from a right to payment and a payment of a royalty.
Well, I mean, they're dealing with a different form of property, and they're using a different drafting technique in order to set up the taxing right. I think they're the 2 points I'm seeking to make.
Thank you.
On the commentary, we were taken to, I think, paragraphs 8 and 8.1 in the 2005 commentary.
Page 8, 10,
Page 8, yes, exactly. Electronic page 810. So 30 Street, tab 29. And the relevant extract, which I think we're asked to note, is 810. Now, the court will obviously read this, I'm sure, for itself. I'm not going to read it all out again. I make the point that paragraphs 8.1 and 8.2, they are not dealing with a situation where a person who holds a license transfers the license and gets a right to payments in return for the transfer.
Sorry, before we get there, the middle of, I know it's only 8.1 that's sidelined, but the middle of 8, the first paragraph of 8 is relied on, I think, isn't it?
Yes, I think it is.
The bit in the middle that says the definition does not apply to payments made to someone who does not himself own the right. Clear.
Yes, I think reliance is placed on that by Milan and Fran.
I certainly highlighted it yesterday, so I think.
No, absolutely. What I was looking to say was that the context of this discussion, one does also have to take into account 18.
Sorry, 18.
18, yes. Because if you see, you weren't shown this. At the end of the passage, which my Lady Justice Asplin would have highlighted, you see in brackets C, for instance, paragraph 18 below.
Yes.
So we should go to paragraph 18 below, which is at the bottom of page 816. Perhaps I could just ask you to read paragraph 18. What they're dealing with there in 18 is a circumstance where services are being supplied. And if one reads on to paragraph 19, that makes clear that when it comes to the working of mineral deposits, etc., it's Article 6 that governs. Now, if one goes back to 8. Would you just give me one moment? I just want to check. I was going to make a point about 8.2, but I say 8.2 only actually came in 2017.
Yeah, I
Yes,
think
I think
8.2 is
and
there.
if it would, yes, and seeing as it's not referred to, I think I'm just not going to take up time with it actually.
Sorry. Can you clarify for me the point you're making on 18?
Well, what I'm saying about 18 is that the particular example that's given is a case of services being provided, and that sheds light on the general observation that is made in paragraph 8. My position on Article 12 is that there isn't anything surprising, and the Upper Tribunal, in my submission, dealt with this point correctly. There isn't anything surprising, given the nature of a royalty as a payment for the use of something, that one might say that one would anticipate that the payment has to be made to the person who owns the thing that's being used. There's nothing in the nature of the payments that we're talking about for Article 6 purposes that would import any similar limitation. That's the point I'm making on the comparison between Article 12 and Article 6, and it's why in my submission it's so dangerous to do an exercise of dipping into other parts of the commentary and looking to relate them then back to Article 6. Fully accept, of course, one reads the treaty as a whole, but one has to do that bearing in mind the different context of the different provisions. Fourth item is to deal with Article 13. And my learned friend has sought to make a lot of Article 13, both in writing and orally, and to build that into a more general point about the relationship between Articles 6, 7 and 13. Now, the point that's taken against me is that it's said that Article 13.4, first of all, is a similar point in relation to 13.5 that I can deal with more briefly, because it's a similar point that arises. But it's said that 13 sub 4 would be otios if the fifth limb of Article 6.2 were to encompass rights to payments on transfer of the right to work. That, among other places, it's paragraph 43 in my learned friend's skeleton. And it was repeated already. Now, in my submission, the Upper Tribunal was correct to reject that argument. It's Upper Tribunal paragraphs 132 to 139. It isn't right to say, for example, that because a right to drill is identified as something in addition to immovable property in Article 13.4, then it follows that the fifth limb only applies to a grant of the right to work, because it's that last step that learned friend needs in order to make good his point that one limits Article 6 by reference to the grantor. One must always remember, in the context of the fifth limb in Article 6.2, and I made this point already, that the immovable property is the rights to the payments. That is the immovable property. Article 13.4, if we go back to our treaty in Authorities, Volume 1, Tab 4, Article 13 at page 51, Article 13 sub 4 is not dealing with the alienation of the rights to the payments. It's dealing with a number of other listed items. So Article 13.4, for example, is dealing with the right to explore for the oil itself. That's one of the items that's listed in 13 sub 4 sub A. Now, we, of course, are asking a different question in Article 6, and that different question is, have we got rights to payments in consideration for the right to work, read short? And if there are rights to payments of that nature, then the rights are immovable property. And, of course, as a matter of function, what Article 6.2 is doing, and we know that from the introductory language, is it's telling us that whatever the general law position in the particular contracting state, then rights to payments within the fifth limb, we're going to treat them as immovable property. But the point that the Upper Tribunal rightly picked up on is that Article 13.4 is not dealing with rights to payments of the kind specified in the fifth limb. And indeed, and the Upper Tribunal noted this in paragraph 133 of its decision, even if you look at the level of the description of the rights being dealt with in Article 13 sub 4, those 13 sub 4 descriptions don't match the rights described in the fifth limb in Article 6.2. The Upper Tribunal said, well, there might be some limited overlap, but the relevant wording isn't the same. But the most fundamental point for my purposes is that what constitutes immovable property for Article 6 purposes is the right to payments. And the one thing that Article 13 is not dealing with is the alienation of rights to payments. So it simply cannot be said in my submission that the revenues construction in this case would make Article 13 OTOs or unnecessary. It's dealing with a different thing. The other way in which my friend sought to put the point was orally yesterday, page 71, which was to say that Article 13.4, he said, makes crystal clear that paragraph 4 rights are not seen by the parties as immovable property. Now, I don't accept the premise of that point. And from my friend's submissions yesterday, it seems certainly not to be right from the point of view of Canada. That was the point my friend sought to draw from the Income Tax Convention's Interpretation Act and their definition of immovable property, which the court will remember looking at in tab 9 of the authorities. But suppose it were well-founded, and one were to say the rights listed in paragraph 4, they're something different to immovable property. It doesn't take my learned friend anywhere, because paragraph 4, and exactly the same point applies in relation to paragraph 5, paragraph 4 is not dealing with the alienation of rights of the type that is set out in the fifth limb. So the real distinction in my submission is between income and capital. Article 6 is dealing with income and Article 13 is dealing with gains. And it's not right in my submission to say that the revenues analysis in this case somehow renders 13.4, and the same applies to 13.5, OTOs. That's not a consequence of what I'm saying. Putting it another way, there is no need for this court to arrive at a more restrictive meaning of the fifth limb in order to give a role or to give meaning to Article 13 sub 4.
But what 13.4 indicates, and obviously looking at the treaty as a whole, is 27A as well, that the contracting parties thought it appropriate, I won't use the word necessary, to make some specific provision in relation to oil and gas. Yeah. It is notable that that specific provision which they thought appropriate to make deals with things that are actually pretty closely related to the oil interests themselves, as you say, the actual right to drill, the right to the assets to be produced. They've gone so far and they've said those should be taxable. The thrust of your argument is that a broader form of right, that's rights, the rights to the payments on which you rely, which is less obviously related to the assets, is nonetheless caught by the general provision of Article 6 rather than the specific provisions that the parties have thought appropriate and which they may have thought potentially extends the scope of the treaty, should be included in Articles 13.4 and 27A. Now that just seems...
My lady,
Do you see what I'm saying?
I understand.
They make some provisions in relation to things that closely relate to the oil.
But it doesn't follow from that. One can't lose sight of two things here. One is that to get home, the learned friend needs to show that his grantor thesis is right, and that this doesn't do that. Secondly, that the way in which he seeks to demonstrate that he's right is to say, on the revenues view of the world, this provision is OTOs. The point my Lady Justice Falk is putting to me is perhaps a slightly different one of saying, well, it may not be OTOs, but it's a clue that there might be a narrower meaning for Article 6. There are a couple of ways of looking at this. One would be to say, well, when we're looking at capital gains, we are focusing on assets. It makes sense from a tax law, international tax law perspective, to focus on particular assets. And indeed, oil rights are particularly important to these countries. I mean, they have gone beyond, if one does a compare and contrast exercise, 4 and 5 do go further than what's in the OECD model. So one can draw a conclusion that it was important to make specific provision for those items. It doesn't follow, though, however, if we're looking at rights to payments, that if we're looking at the income side of things, that a case like this is not covered. The burden of the case that's put against me is in order to make this treaty make sense and to give a coherent result to the treaty, that one has to read down Article 6.2, because otherwise it doesn't make sense. It's said that these items are specifically identified in Article 13. What I'm saying is, no, that's going too far. All you can conclude from this is that it was thought in the context of dealing with gains that there needed to be specific provision. But I've explained why actually when one looks carefully at what the immovable property is in Article 6, that actually there's no incongruence or no difficulty, no incorrect overlap as between 6 and 13. They're dealing with different types of receipt, income on the one hand and gains on the other. The point on Article 13.5, I can do this quite short, it's very similar in nature, because if one has that on 51, that's dealing with gains from the alienation of shares, where the value essentially is derived, it says from immovable property or from any right referred to in para 4. Now, I don't need to say in this case that the shares in SUKL are immovable property. It's back to the same point I made already. It's the rights to the payments that are the immovable property. So again, I'm not making 13.5 OTOs or unnecessary. So the principle identified by Lord Reid in Anson, that the learned friend referred to yesterday, we're not in that territory. Can I turn next, please, to the French text? And very sorry. The easiest place where one sees the two texts together it is actually in the Appendix A to Malone Friends skeleton. That gets both versions on the same page. Prepared one for myself. I'm afraid it didn't occur to me to do a nice landscape one for everybody, but it might be useful to have both languages open at the same time, in which case I think the best I can do is to show you that page in the Appendix of Malone Friends skeleton, page 239 in the core bundle. Now, there are 2 points that arise here. The first is academic, and I really don't wish to take up the court's time with it unless this is something that concerns the court. It was something that concerned the Upper Tribunal, so they asked questions about it and made findings about it, which is whether the French text is incorporated into UK law. The question that is in my submission germane for this appeal is what impact does the French text actually have on the interpretation of Article 6.2? And my position on that is that it doesn't lead to the conclusion that only a grant is covered. On the incorporation point, if I just give the court my position on it, it's probably the easiest thing to do. I say that the Upper Tribunal was right to hold, at paragraph 158 of its decision, that there's nothing in the terms of the 1980 order that incorporate the French text into UK domestic law. It's paragraph 2 of the order, which is Authorities 1, tab 6, page 85. What's provided there is that it's the arrangement specified in the convention set out in the schedule to this order that should have effect. And then you go to the schedule, and all that is set out is the English text. And that, of course, is different to the position in Fothergill and Monarch Airlines, which we mentioned in the skeleton.
It probably is just an academic argument, because, of course, the text in the schedule includes the words the French version has equal.
Indeed. Indeed. And I have no problem with the proposition that this court, being part of the state, is equally under obligations to look to the Vienna Convention and, where appropriate, in accordance with the Vienna Convention, to look to the French text. The analysis has to be struck.
Not just the Vienna Convention, the text of the convention that's in the schedule to the order includes the words both texts are equally authoritative.
That's page 119.
That is true. Yes.
So the question.
But it doesn't. Yes. But it doesn't. Again, this is in my submission.
We may not need to decide it. Just clarify that you accept that because of those words on page 119, we also need to look at the French text.
So I.
If I'm mistaken, that is part of the schedule.
Your Asia is looking at it's the done in duplicate at London.
Yes.
At the end of Article 29.
I am.
Yes.
But it's not. It's probably not in Article 29. It's in the whatever you call it, attestation or execution.
Yes. That's part of the arrangement specified in the convention set out. So one of the things that the court would take into account is the direction that it's been done in two texts and both are equally authoritative. It remains the case, however, that the only thing that's been enacted is the English text. As I said, I don't want to take up time with it because it doesn't matter to what one.
Right. Let's ignore exactly what is enacted. Provided, do you agree that because it says the texts are equally authoritative, that is part of the schedule? That is therefore part of what is that wording about equally authoritative is part of what is enacted.
That is right.
Right. I'm not sure we need to go further, do we?
Indeed, and this because it was a discussion that I'd hoped to avoid in front of the Upper Tribunal, who then were assisted, they thought, by some more submissions on what had actually been enacted. I mean, just so we're clear, whether or not the French text is directly incorporated into English law by being enacted. So if Parliament had copied out the French and put it in Schedule 2 to the order, or not, it doesn't make any practical difference. And the Upper Tribunal explains that in Upper Tribunal 1159.
Right. Thank you very much.
The real point is, do we actually get any help from the French text, and in particular, does it help my own friend get home on his ground one? All the pressure here is on this notion of la concession, and one has to start with noting that it's a particular type of concession. It's la concession de l'exploitation. And that is important because as soon as one starts to look at the dictionaries that my own friend has produced, one sees, and this is an entirely unsurprising conclusion, that the term la concession, it doesn't have one fixed meaning. And in particular, that one fixed meaning is not limited to a grant of rights. The precise meaning will depend upon the context in which the term is being used. And you can see that, for example, from the first of the dictionaries that my learned friend has produced. So this is Authorities tab 3, Authorities volume 3 tab 30. Dictionnaire de droit privé et lexique bilingue. And what this does, I think I'm right in saying, because I haven't had an opportunity to look at whether there's any explanation of what the different terms are. I think page 834 is concession, because that's just that's the noun, so we're looking at the English there. But I'm interested in la concession in NF at the top of page 835, which I think, I'll be corrected if I'm wrong about this, but I think that's dealing with the French term. And what one sees, going through the French, is particularly at point rem 4, halfway down.
So this isn't a translation of the previous page?
I don't believe so, no.
Oh, okay.
I thought, when I first looked at it, I thought it was, but when you'll see that, you'll see that obs are only 1 and 2 on page 834, and you actually get rem, which presumably is a remarque, on 835.
Where are you on it?
And I was simply looking at rem 4. And I'm sorry, because we haven't had this translated. I'm simply doing the best I can with the French, which is the invitation we get from Father. But you can see, le terme concession ne trouve pas d'équivalent parfait en anglais. So no perfect equivalent in English. And then il est parfois rendu par grant. So sometimes it's rendered by grant. But then you read on, after the brackets, mais aussi par une variété de termes spécifiques à un contexte juridique particulier, but also by a variety of terms specific to a particular legal context.
Okay, and then it goes on to refer to what looks like concessions as in concessionaire arrangements.
Yeah, by way of examples. That's one of the examples it has in mind. So my starting point with this is I quarrel very fundamentally with the exercise that's being urged upon this court by reference to the French text, because what you're looking at is a term that takes its meaning from the particular context. What you cannot do is assume by reference to other texts that there is some limited meaning that one gives to the French term la concession, and then say that that must be used to limit the English notion of the right to work. That is an exercise which in my submission is misconceived in principle, because there isn't some invariable meaning of French. One would have to look at this contextually and to do a much more detailed and sophisticated exercise if it's to go anywhere. And certainly none of the materials that have been relied upon by RBC in this case demonstrate that a concession may only be transferred by way of grant. As we say in the skeleton at paragraph 40, they are all in very different contexts to the present case. And none of them in my submission can be taken to govern or inform the meaning of the particular term, which is not just la concession, it's la concession de l'exploitation, which we have in Article 6, sub 2.
Okay, can I just draw your attention on page 834?
Yeah.
It's a bit easier to read because the final couple of observations on that page. Observation 1. Contrast assignment. Concession implies that the concessor continues to have rights, often ownership rights, in the property he or she conceded to the concessee.
Yeah, indeed. And I touched on that in our skeleton.
Yeah.
It implies, I say, just should be taken as they might do, they might not do. It doesn't mean that is part of what a concession is.
It goes on to make that reference to distributorships, which is quite similar to what you took us through on the next page.
Yes, indeed, although with fewer observations than the one on the next page. That's right.
Can I, just as we're looking at this, point out that 835, the little 2, which starts acte juridique, does deal expressly with a right of exploitation. And it does suggest that this is where one person accords to someone else a right over goods property which belongs to him or her. So in the context of a right of exploitation, this bilingual text does suggest that it's by contrast to what it calls cession, if you look at remark number 1, that the concedent does continue to have rights.
Well, in the particular example, because 2 is I think I'm right in saying a quotation from the book, Payet, Sûreté, that's later referred to. So that's one example. What I'm saying is that one cannot take this as being an invariable rule. None of the material that's been put forward shows that this is some invariable rule.
No, but you can get assistance from the normal meaning of a word, even if it's not what it always means. The core meaning of a word does tend to shed some light on the concept that's being sought to be encapsulated.
Sure.
This seems to suggest that the core meaning of concession is to be distinguished from the core meaning of assignment. That's why it's usually translated as grant rather than transfer. I understand entirely. It has different senses in different contexts. But for what it's worth, this text does, it seems to me, give some support to the suggestion that the use of the word concession is focusing on a grant by an owner of property in which they retain some rights rather than an out-and-out assignment.
No, I think where I quarrel with the proposition your lordship just put to me is in the notion of core meaning. That in my submission is taking the matter too far from quite a slender thread.
Okay.
What one ultimately would need to be doing, and this is the exercise in the Vienna Convention, is we're dealing with two texts presumed to have the same meaning. The English text is not on its face limited in the way that my own friend argues that the French text is limited. One has to ask first, well, is there actually linguistically an apparent difference of meaning? So one would need a much greater exercise of looking at the French rather than a sort of an impressionistic approach that has been the hallmark of this aspect of the ground of appeal. In the event that one were then to conclude that the French is or might be narrower, there is then an issue, what is the meaning that best reconciles the two texts? Because it certainly would not be the case that the French somehow automatically governs or restricts the English meaning. One would also have to take cognizance of the fact that in English, the parties have used the term working or the right to work. They've used different concepts which don't carry. If we assume that Nugee is right against what I've said about it's not core meaning, that there is some core meaning that's narrow, that is not a feature of the English text. And so one would have to ask the question, well, is a broader meaning or a narrower meaning appropriate? And the submission I've made is when one looks at this as a matter of principle, there's no good reason for distinguishing the situations of grant on the one hand and transfer on the other.
Yeah, thank you.
So those are the submissions I'd make in relation to ground one. And the nub of it is that one, I fully accept that one reads 6.2 purposively in context by reference to the treaty as a whole, all of that. None of the items relied on justify the restrictive reading that's necessary in order for my own friend to get home on his ground one. Now, ground two, so we're assuming here that a transfer is capable of engaging Article 6.2. What we're interested in is whether the rights to the payments actually are consideration for the working of or the right to work the oil in Buchan. Now, Lanfrand accepts that having acquired the right to the payments by way of assignment, then RBC, I think the way he put it, was stands in the shoes of Sulpetro. And so when we're analysing this part of Article 6.2, you can test what the payments are for by looking actually at what Sulpetro got under the SPA. Now, for that reason, as it happens, paragraph 8 of his skeleton, Lanfrand paints a picture of the sort of great importance of this appeal, and banks up and down the city said to be very worried about the outcome of this appeal. It seemed to be the nub of it. It seemed to be suggested that any person making loans to entities with natural resources activities, that they might be taxable in the source state. That isn't the position. The reason that we're here, it arises from the particular circumstances in which RBC came to acquire the rights to the payments. I am not saying that, for example, in any case where there is a loan and the loan stays on some limited recourse terms and there's a repayment that one can say, well, ultimately it comes from the proceeds of oil production. I'm not saying that that's called. I don't need to say that. If the lender is getting repayment of his loan, he's getting his money back as lender. The difference here is that RBC took an assignment from someone who had rights to payments of a particular nature. And it might just be worth showing the court, we haven't looked at these, the particular court order and the actual assignment itself that actually shows RBC stepping into Sulpetro's position. Court order is in supplementary bundle, tab 14, page 139. And one can see it's an order by the Alberta Court in response to an application by the receiver manager. And then the assignment is effected in paragraph 5 of that order, which is on page 140. And then what appears to have happened is that that is then put into effect by an assignment document, which is within divider 14. There's a covering letter on page 143. Letter from KPMG. And the assignment starts at page 144.
It's in the next tab.
Well, I'm very sorry. It's 15.
No, it's fine.
Tab 15. I'm very sorry. Covering letter at 143. The assignment starts at 144. And one sees a little of the history of it in the recitals. And the assignment itself is in paragraph 1 of the operative part on page 145. And the consequence, or the immediate consequence of that, is that Sulpetro's indebtedness with the bank gets credited with the sum of $1. So that's where we see the bank taking over the contractual rate from Sulpetro that Sulpetro previously held against BP. And that's why I say there really is no analogy with the much more general case that my own friend was hypothesizing in paragraph 8 of his skeleton. Now, both the first tier and the upper tribunal, in my submission, correctly concluded that when we look at the SPA and the creation of the clause 5.4 right, which is the right that's generated the payment, that the right to the payments is consideration for the right to work the Buchan Field. And the case that's made against me is that that is not so, essentially because it's the subsidiary SUKL, which in my learned friend's submission had the right to work. And the reason that's said to be the case is because it's SUKL that held the title to the license. Now, as the Upper Tribunal said, and this was paragraph 177 in its decision, one does have to identify precisely the relationship which existed between Sulpetro and SUKL pursuant to the actual illustrative agreement. And there is a danger of getting carried away, because on a number of occasions, my learned friend seeks to characterise the nature of the rights that Sulpetro had as being a right to the oil won, and the implication behind that is, well, oil once won is movable. That's not a right to work, and it also ties into the points that were being made about Article 13.4, but that is not a complete statement of the rights that Sulpetro had. Sulpetro was not just a passive investor. If we look at the illustrative agreement, tab 1 in the supplementary bundle, starting at page 4, and it's particularly Article 5, halfway down page 7. Not only is Sulpetro, which is the analogue for Signal here, to provide the funds and equipment, and also, as it happens, it's to provide funds for all expenses, including payment of the royalty called for by the regulations. That's actually the royalty due to the Crown, I think. Sulpetro is also providing the budget and the work programs, and importantly, such programs shall be carried out. So what Sulpetro has, among other things, is a contractual right to require its specified work program to be carried out in the Buchan Field. And then looking at Article 6, it's Sulpetro that gets ownership of the petroleum won from Buchan, and then there's a responsibility to deal with the oil in a particular way, in particular ways.
Do we have any evidence as to who carried out the programmes? Who was employed on the rigs?
I can't help.
There is a suggestion, I think, from the SPA. There are references to in the SPA. There are references to an operator. So it looked to me when I looked at that it suggested that the Buchan Field was being operated by someone else, as would often happen, given that this Sulpetro only had a 12%.
Yes.
And that may tie in. I'll just say one thing before I forget, and then if my own friend's able to help, I'm very happy for him to do that, just so I don't forget the point. It may tie in to a document that we haven't looked at, but which is one of the draft novations to the SPA, which is a novation agreement to a participation agreement, which is Electronic 72, which does suggest that there are a number of different entities with interests in the field.
Well,
and then that ties into there being an operator that actually does the doing.
My friend is right. There were a number of other unrelated parties who had interest in Buchan, and they, between them, agreed to appoint an operator under a joint operating agreement. That operator was BP. Now, what I don't know is whether it's the same BP entity that is the counterparty to the sale and purchase agreement, but it is a BP entity.
I'm grateful.
It's in the accounts.
So at the point that Sulpetro was making this disposal, as you said, it had the right to, what's accepted, it had the right to direct the work programs. But it appears that there was an operator that wasn't Sulpetro, it was BP.
Actually doing the, yeah, but I don't.
And there must have been some sort of operator.
And I don't have any difficulty with that. Equally, I fully accept that the entity to which the Crown granted the licence would have been SUKL. That's been accepted throughout. But my position is when you look at the carving up, if I can put it that way, of the various rights in this case, and particularly the separation of license, which in my submission really is little more than the piece of paper that is within SUKL. The economic benefits from the oil are going to Sulpetro, and also Sulpetro has the right to direct that which shall be done. And I say, whether you look at this in a legal sense, or whether you take a broader practical commercial sense, that is enough in my submission to conclude that it's Sulpetro, either on its own, so looking at the right to direct and the right to the oil won, and or through its ownership of the shares in SUKL, which enjoys the right to work the Buchan Field. Alternatively, and I'd say on any view, it's Sulpetro together with its subsidiary that would hold that right. Now, the reason I say that is that one has to look at the notion of the right to work in the context of Article 6 itself, and it's not right in my submission simply to jump to the conclusion that right to work is to be equated with right to go and explore, or right to go and drill, or similar. We're not simply talking about exploring or drilling oil out of the ground. What we're interested in the context of tax treaty dealing here with income ultimately is money. So in my submission, at least part of the right to work must include being able to turn the oil to account. Now, that may not be the only component of the right to work, but it must be part of it, because otherwise you'd be drilling for the oil without being able to actually make any profit from it. And it was that sort of thinking in my submission which rightly informs the first tier's observation at paragraph 59 in its decision, that part of the right to work for natural resources must include, it felt, the ownership of those natural resources when won from the oil field. So one might put it in terms of the right to commercialise the oil as being part of the right to work.
Did you say that was paragraph 59?
In the FTT it is, yeah. And that is echoed in the approach that the Upper Tribunal also took. One also needs to appreciate that the draftsman of Article 6 is not in any way specific, and I would say is not interested in the manner in which that right to work is created or constituted. So it could be contractual rights, it could be rights of a proprietary nature. Actually, there's no reason why it couldn't be through holding shares in a company. But as it happens in this particular case, I don't need to go that far, because we're not looking, if we focus on the disposal of the shares in SUKL, that this is not a case in which SUKL is winning and working and benefiting from the oil, and shares in that company are sold. This is a case where the economic rights, and if one might call them the regulatory rights, have been separated. And one has to apply Article 6.2 against that factual background.
But what is a license other than a right to work?
Well, but
When held, I know that you're saying SUKL didn't get its hands dirty, let's put it that way. But what is a license if it isn't a right to work?
Well, Melanie, the point I'm making is that the right to work includes the license, because clearly no
Yes.
one could go and drill in. The
No,
North
but
Sea
you're saying it's
without
to
a license.
commercialise also.
But
But
what-
but even the license surely enables you to do that, to commercialise.
The point is that those rights to commercialise, they have been sent elsewhere. Under the illustrative agreement, we looked at that
Yeah,
a moment ago. What I'm saying is that the nature of Malone Friend's case on ground 2 is, and this is an unspoken premise, so he hasn't accepted this, but in my submission, the assumption that must underlie his case on ground 2 is that right to work equals license. That's what he needs in order to say the only thing you need to focus on here is that there was a sale of shares.
Yes.
The shares were in a company which held the license, so the right to work never
And you've taken us to
moved.
the illustrative agreement to show the separation.
I'm so sorry, Melody.
And you've taken us to the illustrative agreement to show
Yes.
the separation.
To show the separation, and the point that I make is that a contextual reading of right to work in Article 6.2 must be broader than just the license. No doubt it includes the license, but it's not limited to the license. Test it this way, my lady. If one looks at it from BP's point of view, BP needs all of the rights that it acquired in order actually to go and make money from the Buchan Field. It's no good simply buying the shares in SUKL, because it would then be stuck with the obligation to carry out the work programmes being directed by Sulpetro to put up the money and Sulpetro to own the oil one. That wouldn't have suited anyone.
Right. That assumes, it was a question I should have asked you earlier. When at the end of Article 5 it says, and such programme shall be carried out, the submission you've just made assumes that that's an obligation imposed on the UK company. Is it not an alternative reading that such programmes shall be carried out by Sulpetro? Sulpetro shall provide the budget and the work programmes and carry them out. It doesn't actually say who it's to be carried out by.
Well, in my submission, that given that it is SUKL that has the right to go and do these activities, because it is the repository of the licence, the reading that makes sense of that clause is that it's that entity, SUKL, that has to go and either do the doing or see to it that the doing is done.
Presumably that would be on the basis that, for the obvious reason that Sulpetro doesn't itself hold the licence and therefore it's not entitled to do that
Indeed, and one sees that
activity. Work.
And it may assist in answer to my Lord Justice Nugee's question to go back to Article 2 in the illustrative agreement, which is at the top of page 6. It's licensee, which is to conduct petroleum exploration operations. Licensee there is the analogue to SUKL. And that would fit the reading for which I contend of Clause 5. It wouldn't fit a reading that says that it's Sulpetro that's to go and carry out the work.
Yeah, in fact, it's quite explicit, as applied here. SUKL shall conduct the operations, shall develop the areas, and shall produce the
Now,
petroleum.
of course, and I take...
But it doesn't do it itself, because we know that SUKL wasn't doing anything in terms of actually doing the work.
And we know, and I'm perfectly happy to accept for the purposes of this, I can't remember us getting into the detail of this in the first tier, that there was an operator that was actually doing the drilling. None of that damages my analysis, because we are interested in the right to work. And so what I'm saying is you look at who gets to direct what is done, who gets the benefit of what is done. You look at the regulatory position. Yes, of course, the license is in the company. It's got absolutely nothing else. The company really is just an empty shell.
Well, I want to be clear about this, because looking at Article 2, I see your point on Article 2 and Article 5. As between Sulpetro and SUKL, what Article 2 does is say SUKL should carry out the work. And it's true, at the end of Article 2, it says it doesn't have to do it itself, it can get someone else to do it for it, which was what we assume actually happened, which would fit with the fact that there's an operator, and SUKL only has a 12.7% interest in the field anyway, and you have a single operator on behalf of all those who have interest in the field. Yeah. But as between Sulpetro and SUKL, the responsibility for performance, exploration, development, production, is pushed from Sulpetro onto SUKL. And it may be that was a condition of a license, we don't know. But there's no doubt that the obligation is on SUKL. Now, as I say, actually what happens is SUKL lays off that obligation, as it is entitled to do, onto an operator, but it's not Sulpetro doing the work.
No, and my case doesn't depend on showing that it is Sulpetro doing the work. I don't need,
So
I don't need
what
that proposition to
sense,
get.
in what sense is Sulpetro does Sulpetro have the right to work? Because your case is, it's that right, the right to work, which it has sold to BP for these payments, the right to these payments. You have to show that Sulpetro had the right to work. The place you find it is in the illustrative agreement, because it's the illustrative agreement that you rely on as showing Sulpetro's interest in a non-technical sense in the Buchan oil field can be regarded as a right to work for the purposes of Article 6.2. My question is, the way the illustrative agreement appears to be set up is, as between the two of them, the work's to be done by UK. Sulpetro's got to provide the money, it's got to provide the programs, but it's UK that has to carry them out, although it can, as it did, get someone to do it for them. So why do you say Sulpetro enjoys under this agreement the right to work? What it really enjoys is the right to tell UK how UK is going to do the work. So is that easy and is that enough?
So I think I understand Your Lordship's question. In my respectful submission, that the premise that underlies that question is that Your Lordship's question is equating right to work with right to operate in the North Sea.
No, I'm equating right to work with the obligations in Article 2 put on UK. Licensees shall conduct petroleum exploration operations if petroleum is discovered to develop the areas and produce the petroleum therefrom. And all that looks to me like working a mineral concession, working the right to the Buchan oil field. And my question is, given that Sulpetro's agreed with UK that that's what UK will do, in what sense does Sulpetro have the right to do that?
Because I'm looking in the round at, if you like, both ends of the story. I'm relying on Sulpetro having the right to direct, but also the right to the benefit of what comes out of the work. Because I am looking at that notion of the right to work probably in a slightly broader sense than the sense.
I think it is the right to set the programme and direct SUKL what to do, isn't it?
It's more,
plus get the oil at the end.
And both bits are critical. And what I'm saying is that in the context of a tax treaty, which is all to do with profits and deriving income from natural resources, you need all of those elements of the rights, and one shouldn't simply be focused on erecting oil platforms, for example, and who's doing that in the Buchan Field. It's the beginning to end of commercializing those resources. So it is using the right to work in a broader sense than simply doing the doing. And right to direct what is done, right to the end product of what comes out. They are, in my submission, important features of the right to work here. And that, I would also say, it's relevant to take into account the fact that you have ownership of the shares in the company, SUKL, which company actually has no real economic entitlement here. That's a relevant factor to look at here in testing. Who actually has got the right to work. Putting it another way, it would be an artificial conclusion in my submission to say the entity with the right to work is SUKL because it's the entity with the license. And the reason for that is that it has no ability to specify what work is going to be done and no entitlement to the end product of the work.
Well, that's because it's restricted its position by entering into a contract with Sulpetro. But if you look at the licence as between SUKL and the Secretary of State, that gives it the right to work. It then is then turned around and entered into a contract which confers certain rights on another person.
Well, as I understand, this was all entered into as one package. It wouldn't be right to look at it as some sort of sequential.
I'm not sure, because we're told that the illustrative agreement replaces a previous informal understanding. So we don't have the evidence of when the licence was granted.
Well, all right, but, no, I think that is right. But in which case we equally don't know that it was the sort of sequential approach that's just been postulated.
Oh, sorry, we do, because oh well, no, we don't, because we only have it from the illustrative agreement with Sigma.
If I may say that it is one of the difficulties in this case that we're asked to. So we obviously know that there was an illustrative agreement because it's referred to in the SPA. I certainly wasn't going to submit that the burden of proof hadn't been met because the piece of paper hadn't been turned back. So we're doing the best we can, making assumptions that it's the signal agreement, something like very like it would have been entered into. What we're interested in is the position prior to the sale to BP. That's where we started with this, was with my Lord Legislator Nugee's question, which I think was directed at saying, well, you're relying on the sale to BP. Let's look at what they had first, because if Sulpetro did not have a right to work, they can't very well have transferred it. It's the burden of it. And my submission is to look to answer that, to say, well, look, as at the date of the SPA, these are the rights that Sulpetro, the parent in Canada, had, and those rights answer to the concept of a right to work the oil. And I fully accept I have to put together the right to direct, the right to the end product, and I may also have to add into the mix the interest in the shares in the company. I say that's good enough.
You say that economically it's the parent in Canada which has the interest in the field, even though the way it holds that interest is by having shares in a UK company which holds a licence. But it's the board in Canada, not the board in England, which decides how much money to spend, commissions, the drilling and so on and so forth. Although actually it doesn't do it itself, because there's an operation doing it for everybody who's got an interest in this field.
If you're asking who has the economic interest in the exploitation of the field, it's Sulpetro, it's not SUKL. The economic interest passes through SUKL.
And that's the essence of your point. Basically, the license is a piece of paper, but the economic reality is that the parent has the relevant rights.
No, my learned friend wants to take a much more legalistic approach of saying, well, there's a company, and maybe there's a piercing of the corporate veil or something. I'm not needing to pierce the corporate veil. I am simply saying we're dealing with a treaty. We're told again and again that these instruments are to be interpreted not by reference to particular domestic techniques. It's on the broad principles of international acceptation. We look at it in context, and one has to take a realistic view of the matter. And when you look at the rights that Sulpetro had, I've made the point. We get...
well, Sulpetro go to BP and say, we're going bust, do you want our interest in the Buchan Field? BP says yes. What Sulpetro is doing is giving BP Sulpetro's rights in the field. And the rights in the field include the right to get the oil out and keep the oil. Now, you have to do that through the mechanism of having a UK subsidiary, but you say it's all Sulpetro that's got the rights in the field.
And just, yes, I'd agree with that. And the just to add that the mechanism should not be determinative of whether we're within or without the fifth link. And as it happens, just adding to the point my Lord, just as Nugee has just made, I simply give the reference. We observe in the skeleton, it's paragraph 60, that characterisation about the interest transfer, that actually matches certainly BP's view at the time, and also what KPMG was saying. That obviously that doesn't bind this court, but the letters are in the bundle if you want to see the passages that we've quoted in the skeleton in the original. But you're not going to get very much help from what BP itself thought. What matters is what has actually been done. Those were the points that I wanted to make in relation to Ground 2. That takes me almost to the points on the Respondents' notice. It's probably convenient to deal with those when I'm still on the treaty. Just before I got to those, there is one topic I couldn't quite fit it in very neatly into my submissions, I'm afraid, but I thought I should just say something about double taxation, which was one of my own friend's big picture points. This was on page 8 in the transcript yesterday, among other places. It said, well, RBC faces double taxation if the revenue's right in that case. I say that assertion is wrong. It's wrong whether it's put in terms of double taxation. It's also wrong whether it's put in terms of a high effective rate of tax, which is the way that the matter was put before the Upper Tribunal. It may be that that's no longer pursued. I say it's wrong, certainly in the sense that the assertion doesn't give this court any help in how the treaty ought to be interpreted. But it's also wrong because under the treaty there is provision for RBC to have an entitlement to credit in Canada for the UK tax. And you see that in the authorities. Within the version of the treaty we're looking at in tab 4, starting at page 42, within Article 21, which is at page 54.
Oh, sorry, tell me again. We're in Authorities 1, tab 4, page...
Authorities Volume 4, and it is page 54.
Thank you.
Article 21.
Yes.
And it's particularly paragraph 21, sub 1, sub A. And the point, as a matter of principle, is that there's a deduction for tax payable in the UK on profits, etc., from any Canadian tax payable in respect of such profits, etc. Now, my own friend has said, well, our understanding is we're not going to get credit. And certainly, I think below it was said, well, 21(1)(a) is subject to provisions of the law of Canada. Now, no doubt there are procedural requirements that would have to be fulfilled. For example, time limits. I don't know what those are. But provisions of that nature don't inform the interpretation of our treaty. What I'm saying is that as a matter of principle, if you look at the way this treaty is organised, the thesis is that there is an article which deals with the elimination of double taxation, and it does so in a particular way. So there's no difficulty. In the event that taxing rights have been asserted and the UK is entitled to assert those taxing rights, so there's tax in the UK. If the Canadians also say, well, we think this is business profits and it's profits from your banking trade in Canada, where we should then be looking to the answer is Article 21. One should not, in my submission, be saying, we need to do something about Article 6 because there's a problem that's arising because of Article 6. That's the point on the elimination of double taxation.
That would be your position, even if, as a matter of fact, Mr. Peacock is right in saying we can't get the tax back in Canada, and we're going to suffer double taxation.
Yeah,
well, that's what he's told us. We're not in a position to resolve that. It's a matter of Canadian law.
It is, and there's been no evidence below about what the position in Canada is. So this court, in my submission, can't embark on an analysis of, well, would the Canadians be right to seek a tax charge in Canada or not? Because as you rightly says, that's a Canadian law issue. But the answer is that if we are in a place where both states have asserted taxing rights, the treaty has its own mechanism to deal with that, and that's in Article 21.
We don't have to be satisfied that Article 21 would be operated to the benefit of RBC. No. All you're inviting us to do is to say, it's not an answer to our construction of Article 6 to say we're going to suffer double taxation, because the treaty contains provision which is intended to address that, whether it does or doesn't in practice.
That's exactly right. And that ties in, if one goes back to Article 6 itself. Article 6(1) it is permissive, and it's not giving an exclusive right to tax. So it's simply saying that if we've got immovable property, the income from the immovable property may be taxed in the state in which the property is situated. It doesn't say it's taxed only there. And so the treaty itself contemplates that you could have situations where both states have taxing rights and indeed have exercised them. That's what Article 21 is there to deal with.
Under Article 7, Canada does have taxing rights because these are profits of a banking business carried on in Canada.
Indeed.
And Article 7(4), which says the provisions of other articles are not affected by Article 7, doesn't mean that Article 6 overrides Article 7. It means that both Articles, if you're right, both Article 6 and Article 7 give taxing rights, and then Article 21 is meant to sort out what happens if both those rights are exercised.
That's exactly right.
And it might follow from that if you're right on Article 6, the rate of corporation tax in Canada was higher than the rate of the UK tax, unlikely in the event of offshore taxation, but in principle, it wouldn't eliminate the right of Canada to tax under Article 7. It would just act as a deduction from the tax payable under Article 7.
I think in that example that would be right. Yes.
Yes, a very simple example would be rental income from the UK owned by a Canadian resident paid under deduction of basic rate tax, where there'd be top-up tax in Canada.
Yes, Yes, I think that must be right.
This may all be very obvious to everybody else in the room, but I'm grateful to you to explain it. Thank you.
But I hope that deals with the point on double taxation. It is also just worth noting if there is still some complaint about effective rates of tax or high rates of tax in the UK. What the treaty is not doing is constraining the manner in which the UK taxes the gain. You can see that in paragraph 4 of the commentary on Article 6. So if the UK has taxing rights, it can set such rate as it wishes.
Sorry, you said that was in the commentary on Article
Yes,
6.
it's the commentary on Article 6, and it's paragraph 4 of that commentary.
Thank you.
As long as it's non-discriminatory. You can't impose extra tax on committees.
Yes, subject to those sorts of points. Yes, it's not a free-for-all, but it's the final sentence of paragraph 4 of the commentary, which in the version you've been looking at is electronic page 883, if you would like to look at it. It should further be noted that the provisions of the article, that's Article 6, do not prejudge the application of domestic law as regards the manner in which income from immovable property is to be taxed. So that's the point on double taxation. That takes me to the two respondents' notice points on the treaty. Both of these were run out in the Upper Tribunal. The first of them, the Upper Tribunal said it didn't need to decide, and it wasn't going to decide. That was the appeal to the more general definition of immovable property in Article 6, and it didn't need to decide it because it held that I'd got home on 6.2. And then the second respondent's notice point is in relation to Article 13. And I'll deal with those, if I may, in turn. The Article 6 starts, if one goes back to 6.2, I suppose I should just make clear when I'm making my submissions rather than I think I nodded during my learned friend's submissions. My learned friend wants to characterise this as he calls it a 6.1 point. It's not really a 6.1 point, it's a point that's to do with what does immovable property mean as a matter of the construction of that concept in the treaty on the footing that I've failed to get within the fifth limb. And so I suppose if we're plugging that into the paragraphs in the treaty, it's still a 6.2 point, because 6.2 tells you what immovable property is. It's just a different bit of 6.2. Nothing turns on that. What I say on the first respondent's notice point is that we are interested, leaving the fifth limb to one side, we're interested in how the UK law treats these payments, because we're pointed to the law of the contracting state in which the property in question is situated. And in the end, it is really quite a short point. We say that the income that RBC received, that's been directly derived from the exploitation of the Buchan Field. The payments are, if you like, a slice of future income from the Buchan Field. We're looking in Article 6.2 at a concept of immovable property that is not intended to be narrowly drawn. We're looking at, first of all, what's done in the law of the contracting state, and then the series of extensions in the first to fifth limb. What we have in this case, if we look at the UK tax law, and that's a permissible part, I would say, of the law of the contracting state to be looking at, is payments taxed as profits of a ring-fenced trade. And the ring-fenced trade concerns the exploration or exploitation of the UK sector of the continental shelf. And so in that broader sense, if one's looking at these payments from that perspective, we have in my submission payments which, on any view, derive from immovable property in the UK, being the rights within the continental shelf.
Just to be clear, that what you've just said presumably assumes that the appellant does not succeed on ground 3, because your starting point is that the domestic law says this is ring fence income. Well, there's the point that the immovable property is the subject matter rather than the income. You need to address that, but you're referring essentially to section 1313, aren't you? And you're saying that is part of the law, if I've understood you, and that's sufficient to show that this sort of arrangement falls within the concept of immovable property.
And that's looking at the concept of immovable property more generally than, and I hesitate to say without regard to the fifth limb. It's without regard to the fifth limb in the sense that I don't need the fifth limb if I'm right about the point that I've just made.
But does 1313 characterise the ring fence as real property or immovable property? It doesn't need to, does it?
It doesn't need to, but what you would do is you'd read 1313 with the definition of the territorial extent of the UK in Article 3, which includes the continental shelf, and that is, as a matter of general law, I don't understand this to be disputed, immovable property. So what I'm trying to do is to draw together the domestic law treatment and then that definition of what we're talking about when we talk about the UK in Article 3(1)(a) little 2 in the treaty. Your Lordship is right. I won't find in 1313 a statement that the continental shelf is immovable property.
Hang on. Also, Section 1313 deals with profits from.
But it links those profits, my lady, to the exploitation of the continental shelf. That's the link you need to get within 1313.
I'm struggling a bit as to how that means that Section 1313 is a relevant part of the law for the purposes of Article 6.2, because we don't need Section 1313 to tell us that the continental shelf is immovable property.
So, well, the reason I've referred to it is because that helps to explain where the payments are coming from. I suppose the question that my Lady Justice Falk has just put to me might tend to suggest that perhaps I don't need the Section 1313 step for this argument. But all that it would get us to is a place where you're dealing with monies that are derived from the continental shelf. And that would still get you to a place where it is from immovable property in Article 6 terms.
I'm looking at the terms of 1313, and I can well see that it treats the UK section of the continental shelf as property in the United Kingdom. But when it comes to the rights to assets to be produced, i.e. the oil, what it does instead is say that these are profits from activities or property in the United Kingdom. But it doesn't seek to characterise the oil in any sense as immovable property. It just says we're going to treat this as UK activities and UK property, and that's all it needs to do in order to bring it within the tax charge. It doesn't need to characterise the barrels of oil as quasi-immovable property.
No, and it hasn't.
And it hasn't,
And it hasn't
done that. But the actual profit that BP make, which is out of, or Talisman, which is out of which the payments are being made, is from selling the barrels of oil.
Yes, that is true. I suppose the reason for referring to 1313 is that is the link to the continental shelf, at least in the domestic legal
But you've
system.
got it there in the treaty because the treaty covers
And
the
it-
continental
Indeed,
shelf,
and
doesn't
it may be that actually I don't need that.
So you don't need the extension
No.
in that way. do you? I forget where it is, but you took us to it.
In the definition of the UK.
Thank you.
What I think you're really saying is that the payments made to the bank by BP or Talisman when they sell the oil, and which are dependent on the market price of oil when they sell it, are payments which ultimately derive from the exploitation of UK land, the continental shelf. That's what you're really saying.
Put short, that's right.
And that
on
would
this
have,
episode as well.
that would have the effect, wouldn't it, that any bank that lent any money to an oil company might be within that bit of your argument.
No, because what the bank lending money to the oil company would be getting is its return of principal and interest as lender. So you wouldn't be within Article 6. There's a different explanation for why it is that payment is being made.
Even if it's a profit-linked loan.
Because what it's getting back is its loan. It's not as in this case, where the reason this case is different to that sort of case is that when you look at what Sulpetro sold, it was a very specific set of rights that are much more closely linked to the exploitation of the field itself. It's not analogous to a profit-linked loan.
But if the bank, as part of the terms for repayment of the loan, says we will receive an overage above the price of oil at X over a number of years as to go towards what's owed to us under the loan, i.e. they use that mechanism, that way of calculation. For the next X years, your repayments on the loan shall be calculated by reference to, and that goes back to barrels of oil out of the sea. Rather an unusual situation, perhaps. But what would that be?
That's a different arrangement to what happened in this case.
Yes.
That would
Yes,
still,
I'm just positing.
But that would still be repayment of a loan. The thing that makes this case.
Sorry, but why would that still be repayment of a loan?
Because all that is happening is that the loan repayments are genuinely being calculated by reference to the profits from
It's just a
on the
calculation.
oil field. It's a calculation mechanism. What has happened here, and RBC did not need to do this. There could have been a different deal that's more along the lines of the deal that Milady has just outlined. But in this case, and this was why I showed the court order and the assignment, RBC, for no doubt its good commercial reasons, decided that it would step into the shoes of Sulpetro.
It took the assignment. I understand it's different, but you say the mechanism by which you have your repayment of loan in some part by reference to an overage in relation to what's getting taken out of the Buchan Field is still, you say, a repayment of a loan, and it's got nothing to do with these provisions.
Yes, that's right. My lady, would that be a convenient moment? I've got Respondents Notice Point 2 to do on Article 13, which may take a little longer than the first one, and then I've got to do the UK law, which I don't expect to take very long, subject to the questions that you...
And so you feel comfortable with your timing?
I do.
Lovely, thank you. I was just asking that for the purposes of whether we should sit early, but you're content. That's very helpful. I'm sorry because we've taken up quite a lot of time asking lots of questions this morning. Thank you very much again. Then 2 o'clock.
All right.